Good morning, everybody. Welcome to Law and Legitimacy, and I'm speaking to you from the bottom of a tin can trapped in New Haven because once again I left the good microphone at home. This is Norm, Mike. We're back with Law and Legitimacy, and as you know, technical issues are our brand. So I think Sigmund Freud would suggest that I didn't really forget the microphone at home this morning, that I deliberately left it at home so to be brand loyal. But hey, you can hear me, and you're here, and that's good enough. That's good.
I love that you're like, yeah, says who? Mari, good morning to you, Mari.
No, he didn't say good morning. He just said morning, everyone. Now
okay, fair. It just reminded me of that scene in We Were Soldiers. I forget the old man's name. He was in Tombstone too. He played Virgil. Young officer is walking by, older officer. He's like, "Good morning, sir." And he's like, "How do you know what kind of goddamn day it is?"
Well, that's the kind of day I'm having, and it's only Thursday, so the week isn't going to get any better, but it's going to end at some point soon, because all weeks, like all men, and even women, and even those who can't choose a pronoun, all its are mortal. Hey, big news yesterday with lots of ramifications. The United States Supreme Court granted certiorari in one of the three petitions challenging the use of 18 United States Section 1512C in the January 6 prosecutions. And you're like, you want to say that again? Can you?
Jalapeno Jack is popping. He's a jalapeno popper this morning, baby.
Jumpin' Jack Smith is like holding his nuts saying, oh my God, what do I do next? So here's what happened. That this statute, we've talked about it before, is the Sarbanes-Oxley statute. It was amended to capture a greater array of activity. Sections A and B dealt with tampering with evidence or tampering with witnesses corruptly, that is, for corrupt purposes in association with an official proceeding. So you keep a witness from testifying, you destroy a document. That's going to get you in trouble under 18 United States Code, Section 1512, Sections A and B. Some Arthur Anderson prosecutions failed because the statute wasn't broad enough to capture what the defendants did. So Congress amended the statute by adding Section C, and Section C basically says, or otherwise engages in conduct to adversely affect or undermine an official proceeding. You still have to have a corrupt purpose, but it's this otherwise. And what does otherwise mean? Prior to the January 6 prosecutions, this statute had almost never been used in anything that didn't pertain to an actual government investigation or an adjudicatory proceeding, whether it was an administrative hearing, a hearing before Congress in its fact-finding role, or a court proceeding. Federal prosecutors in the J6 prosecutions have taken otherwise to mean everything. And thus, if there's an official proceeding going on and you, with a quote unquote corrupt purpose, do something to undermine it or to affect it, you're potentially guilty of that crime. And thus, January 6 defendants have been charged by the hundreds with the 18 U.S.C. 1512C. And what this statute is a very powerful hammer. Because it carries a 20-year penalty. So if you're a rioter wandering around the hallways of Congress on January 6th, and you go into a congressman's office or you bang on the door of one of the chambers, you could be charged with 1512C and face up to 20 years. And so maybe you should just go ahead and plead to something else to avoid that possibility. Defendants have been challenging 1512C's application in this case on the grounds that this isn't what Congress had in mind at all. And one trial judge bit down on the theory, and he dismissed three cases, including one for Jake Lang, who's a client I represent, Garrett Miller, and a Mr. Fischer. I don't remember Fischer's first name. Those three individuals had a consolidated appeal taken to the District of Columbia Circuit Court of Appeals, and that panel ruled 2-1 that the statute could be used, but the rationale by the government in this fashion. But the rationales offered by the three judges differed. Judge Pan, writing for the majority, basically said anything is corrupt if it's bad. I can't remember if it was Walker or Katz. I just don't remember the judge. The second judge said, no, it's more limited than that, but whatever it is, it's covered by, it covers the conduct of these three individuals. And then the third dissenting judge, I think it was Katsas, said, no, it's none of these things. You can't use the statute this way. We took a petition for certiorari. We asked the United States Supreme Court to review this issue, whether the statute was used in an overbroad way. And we were the first in. We were followed by Miller, who's represented by private counsel, and by Fischer, who's represented by the Federal Defender's Office. Now, there was a lot of pushing and shoving behind the scenes going on to determine who would get to argue this case if the Supreme Court heard it. And the Federal Defender's Office wanted to make sure it was them. So what they did is they went ahead and they got a recognized member of the Supreme Court bar, a lawyer by the name of Olson, to file what's called an amicus brief, a friend of the court brief. Olson has argued, I think, 13 cases before the Supreme Court since 2012. It's an impressive resume.
A hall monitor brief.
Well, but he's known.
Watch the class while I'm away brief and take names so when I come back I can punish people brief.
The Supreme Court bar is incredibly inbred and clubby, and so they hired an inbreed to say, "Let the club come in." And lo and behold, that's what the Supreme Court did yesterday. Certiorari was granted. In other words, the court has agreed to hear argument on this case in full briefs, and they gave that seat to the federal defenders. As yet, the court hasn't acted on our petition, on Lange's petition, or on Fischer's petition. The rumor in the halls is that our cases will be stayed. If you look at the Supreme Court docket sheet right now, you'll see a special notation on the Lange and Fischer cases referring them to one another, but the docket doesn't reflect what the status of those cases is. So, personally, I'm very disappointed. I'm not sure I would have argued the case for Lange if his case had been reached by the Supreme Court. Candidly, I'm not sure I'd have the time to write the briefs right now, but I'd much rather be in a position of saying no than of having no said to me. But here's the real issue on that. Forget my feelings, because after all, I'm a bit player in life. But let's face it, this case really poses a threat to Jumpin' Jack Smith, or Jalapeno Jack Smith's prosecution of Trump, because Trump has been charged with a 1512C count. Now, there's a lot going on in Trumpville. Judge Chutkan last night issued a stay of proceedings in the case pending the Supreme Court's review of Jumping Jack Smith's emergency petition to the Supreme Court for certiorari without judgment. In other words, when Judge Chutkan decided that Trump was not entitled to executive privilege for his utterances on January 6th, Trump's lawyers went to the D.C. Circuit Court of Appeals to review that. The United States government said, "Oh, no. The public interest demands a trial right away." And so they've asked the Supreme Court to intervene. And the Supreme Court said,
"My mouth is hot."
Yeah. Oh, my mouth is hot. Let's do it. Okay, everybody, let's do our Jack Smith look. 1, 2, 3. Now he's either been slapped upside the head with a stupid stick, or assaulted with an invisible dildo, or he swallowed a jalapeno. And so I'm going with the jalapeno, and I'll call him Jalapeno Jack. But in any case, Judge Chutkan said, okay, until the United States Supreme Court decides what to do, we can't hear this case. That was before she became aware, presumably, of the 1512 cert grant. This poses an additional obstacle to Smith's going forward. Smith now has to decide, does he pursue Trump without that count? Or does he wait for the Supreme Court to decide this case on the merits? Now, likely this will be one of the decisions that will be made late in the term in June. I suspect the briefing schedule will require the petitioner to get his merits brief in, probably in February or March, the government to get theirs in March or April, the reply briefs to come in May, and then they'll have arguments set for maybe June. And I think this case will be decided in 2024 rather. If it's not decided by the summer of 2024, it won't be decided until after the general election. And the result will likely be that Donald Trump's trial on interference in the January 6th electoral count case will not go forward prior to the primaries. So this is a huge, huge, huge move on the board with respect to J6, and you know, there should be much celebration about it in Trumpville. Keep an eye on Smith, on Jalapeno Jack, and see what he's going to do.
Here, Norm. Couple things here. We'll keep an eye on Jalapeno Jack, but we can smell his breath, so I'm not going to worry about where he goes. Justin asks, why would the decisions in the 3 cert petitions differ? And I think you have a pretty narrow answer to this, Norm. You, if I understand you correctly, you think this is a very safe or a conservative decision by the court in terms of which one it would hear based on who is bringing the case, right?
Yeah, I'm not sure that the decisions would differ, because the government, you know, kind of argued, and since some of the cross petitioners argued dishonestly in their briefs that Lang was not a good case for cert because Lang was asserting self-defense in his use of force against officers that day. Lang was a participant in what I call the Battle of Thermopylae. That is the confrontation in the hallway in the Capitol, where there was a phalanx of guard at one end and a crowd pushing at the other. Lang was in there pulling people out. Don't forget, Roseanne Boylan was crushed to death in the hallway, and several people were beaten senseless by cops. Lang acted in defense of self or others, and that will be his defense at trial. That's an affirmative defense to the charge of assault on a police officer, that whatever force he used was justified. It doesn't have any bearing on whether he should have been charged with 1512C or not. Miller, by contrast, was merely present in the Capitol for a while, and he's a more polite case. But whatever the Supreme Court does with respect to its ruling on 1512, it's going to have to ask whether there was any justification for it being charged in the indictments in these cases. In these cases at all. And I think that hearing one case can yield a conclusion that decides all 3, or in the alternative, if the court hears just the Miller case, it can reach the issues presented in Lang and Fischer in one decision. So I don't see the need for 3 arguments in this case. Arguably, there wasn't a need for 3 petitions, but you know, each party had their own perspective and their own desire to go, and each one did. So you know, the Supreme Courts have picked one. They didn't pick me. I'm suffering raspberries.
Well, you know who did pick you, Norm? The New York Times, because guess who's not quoted in this article, and guess who is? Just wanted to make that clear for everybody that Norm is quoted in this New York Times article from today that's actually talking about the topic that we're covering right now. So Norm, you know, no moral victories are for minor league coaches, and I'm not suggesting that you're a minor league coach, but they're not going to anybody other than you to discuss what the narrow issue is here. And you're quoted as saying, quote, "The statute has been used to overcriminalize in the J6 cases, and Congress never intended for that." And so you've said everything here. If you're a Law and Legitimacy stream listener and or viewer, you've heard Norm talk about the origins of 1512 in the application of the obstruction doctrine, the origins are in Sarbanes-Oxley, etc. You understand, based on being here, you are more informed than the average bear, and it is this same content, albeit diluted and much shorter, that it is making it into the mainstream consciousness via the New York Times. So Norm, take that for what it is. Okay.
All right, I'll take it for what it is. Severe conservative, you asked Theodore Olson. No, it's a different Olson. I'm not I don't collect baseball cards of Supreme Court of the Supreme Court bar. I'm not a member of the club, and I don't particularly care to keep track of them. But it's a different Olson. He's a younger guy. You know, I can't remember his name. I'm sorry, I'm poorly prepared for that this morning. Justin asks, the appeals won't extend past the election. I don't think they will, Justin. I think that the court can arrange its docket such that it can have a decision in June. It's a close call, though, now, because after all, we're into the Christmas break, and then, you know, somebody's got to write a merits brief. There has to be a reply brief. Then there's a reply to the reply, and then the court has to, you know, research the issue and be prepared for argument. I believe this case, and then make a decision. So I believe this case can be fully briefed and argued in a decision rendered by the end of June, which is the end of the term. But it's a close call. But it's a good call for Donald Trump, because what this means is it's almost impossible for the election interference case to go forward prior to 2024. And if it does go forward, it'll be as a result of extraordinary maneuvering and massaging of the charges by Jack Smith which will be a transparent demonstration to the public at large that this isn't a case about equal application of the law. It's a case about trying to stop Donald Trump's election chances. And, you know, I got to believe that somebody at the Justice Department has a nanogram of sense and will realize that they've got to take their foot off the gas.
Well, and you know, we've got over on Rumble, we've got at least one viewer asking about, you know, how this affects other cases. I don't know that it has a direct effect, but it is worth noting here, Norm, that Leticia James tweets yesterday that they've rested their case in the civil case for financial fraud. And of course, if you've been following the New York State AG account on X for any amount of time, you realize how ridiculous the publicity being generated about the trial without any real transparency to what's going on in the trial has become, especially because of the prosecuting authority being the one delivering these sorts of X updates. And I love this last line. This trial revealed the full extent of that fraud and Trump's inability to disprove it. I mean, how?
But I thought the testimony was that the banks knew what they were doing. They made money and they wanted Trump's business. You know, in a fraud case,
Norm, there's a million views on this. Who cares? Where is it really being tried?
Yeah, you've got to, but in a fraud case, you've got to prove damages. And I don't think Leticia proved damages. But we know that, you know, Judge Engoron.
It doesn't matter if she didn't prove it, Norm. It's explicitly here. It's about his inability to disprove it. Okay.
I don't want to give her any more screen time than we have to. You know, Leticia James is a paperweight in a suit, and you know, I don't know what's going on in the AG's office in New York. I'm glad I don't live there. Hey, so what? You know, Justin Carter, longtime supporter of the show. Thank you, Justin. I know you take our mantle elsewhere and tell people they should be listening, and of course they should. He asked, "What's in our coffee this morning?" Just the normal caffeine. Here's what I want to know. What's in the water in D.C.? Hunter Biden obviously went to the "I'm going to be an asshole" drinking fountain and took a good long gulp the other day. He's defied a congressional subpoena from an oversight committee saying, "I won't testify in private. I'll only testify in public. I won't testify in private because I know that selective portions of what I have to say will be leaked by people who hate my family, and this is just an unfair attack on my family." He's starting to sound like he might be dating Ivanka Trump. I mean, think about that look, you know. "Hey, Ivanka, you want some crack?" "No, thank you. No, you know, I gave it to the office." But I mean, he's running a risk. He's running a risk of a contempt citation, and I wonder if the Justice Department will do it. Congress may not be the wisest group of people ever to fallen out, wisest group of eggs ever to have fallen out of a chicken, but they get to conduct their oversight role the way they choose to. And if they wanted to do a private deposition and they gave him a subpoena and he said, "I'm not doing it. I'm not doing it unless I can do it in public," you know, that's not a call he gets to make.
I mean,
so
they made do it at a press conference
Yeah.
in DC instead of appearing for his closed door deposition.
So they prosecuted Steve Bannon for thumbing his nose.
We need a drug test. That's what I say. We need a drug test. I don't believe he's off of it. This guy's on crack.
Let him put that defense on. If you're gonna hold others in contempt and prosecute them criminally for thumbing their nose at Congress and not appearing as the subpoena requires, it would seem to me the president's son might be as vulnerable. But wait. I think I told you why he might not be charged, because he is the president's son. And so the legitimation crisis continues to spin out of control in DC. We've got similarly situated people being treated differently. The impeachment wagon is left the station, you know, with respect to Trump, or with respect to Biden, rather. You know, I don't know whether there's evidence sufficient to find that he was engaged in high crimes and misdemeanors. I do know one thing.
Norm, look, you're doing too much thinking. Okay. Reuters has thought about this for you, and it is telling you unequivocally that the Biden impeachment inquiry has been authorized, even though there is no evidence. Okay. That's just the way it is.
You know, that's true. And, you know, folks, you should not listen to Law and Legitimacy if you're offended by thinking, because that's what we try to add as value to the world. Hey, Reuters, is this your opinion piece, or is this a news piece? There are people in the American public, Mike and I among them, who wonder how Hunter Biden became a multimillionaire when his only real when his only real talent appears to be selfies with hookers, unshaven, cigarettes dangling out of his mouth, and avoiding taxes. And might that skill be related to the last name Biden? And, you know, I think throwing his dad's name around would justify an inquiry into what his dad is getting, whether his dad's authorizing it, whether his dad's benefiting from it. And so I don't fault Congress for looking. Something unseemly is going on, and we are the left.
And look at this as well. I wanted to at least note that there is the internal strife over the subpoena of Hunter Biden. So now we've got Adam Kinzinger criticizing Jim Jordan for the threat that Jordan levied about holding Hunter Biden in contempt for defying the congressional subpoena, and now it's turned into, you know, just sort of a mudslinging match. So this is a complete clusterfuck. Pardon my French, but we are so far from the 50 intelligence officials signing a document saying that the laptop had all the markers of Russian misinformation, right? And the censorship of the New York Post and the deplatforming of any information related to Hunter Biden's business dealings or his extracurricular activities that might have brought, disrepute to the White House or his family, or his connections to certain we'll call them less than above board affairs. We're so far from any of that. And at this point, it begs the question of, what is Joe Biden's reelection strategy? Because it doesn't appear as though anybody is in control at this point. It feels like you've got 5 pending cases against President Donald J. Trump, who is also the leading candidate for president in this election cycle. You have an existing administration that has a body in the form of a president, but has no ability to run an election campaign. He didn't even have the ability to run an election campaign in his first term. And then you've got this sort of undercurrent that is 2 sort of incumbent parties, right? Both in Republican and Democrat circles. You've got all sorts of speculation around how Gavin Newsom is going to be elevated, and or Michelle Obama. But then you've also got Ron DeSantis and Nikki Haley. And as clear as things appeared to be several months ago, in terms of that, the order of operations and sort of triaging a list of who is most likely to succeed, it feels like everything has been relatively flattened. And I just wanted to point that out. Everything is very confusing. The war in Ukraine seems to be actually crescendoing again. I don't know if you've realized that lately, right? There's more money being spent. Zelensky came to the U.S. here recently, and I think Ukraine is actually going to be conscripting men over 40 now, just to give you an idea of how well that's all
going. Mighty fighting force. I'll know that Ukraine is serious about defeating Russia when they start going after men over 65, because we've got a lot going on. We may not have a lot of energy left. I mean, like, when I hear that song, I want to rock and roll all night and party every day. To me, what immediately pops into mind is I want to rock and roll until 9 and party half of the day, because I need my sleep at night. But when, if Zelensky was serious, he'd be conscripting 65-year-old men saying, "You've got nothing to lose. Give what's left of your life for your country." And that's not me being a stand-up comic. And here's a check from Uncle Sam, $100,000 for you.
Well, ultimately, we're talking about Adam Kinzinger blasting Jim Jordan over, hypocrisy, right? But I find nothing more hypocritical from this scenario than an administration that has used the political tools available to it for the last 5 to 6 years to in every way, shape, or form, from every branch of government possible, to delegitimize the presidency of a duly elected president, and then criminalize the conduct in that presidency through hook and or crook, right? Whatever fit the bill. And then everything that was held back in that dam of sort of the coalition of censorship and judicial and executive privilege, right, is starting to leak through that dam. And now, as we point out the fact that the people who were saying that was all behind the dam and it was being forced back, now that is being pointed out, oh, now that's hypocritical, right?
Well, Seeing Kinziger's name reminds me of something. I'm about done now with Liz Cheney's new book, Oath and Honor, about the January 6th event and her investigation. And boy, I wonder if she'll do an edited version, because, she just despises Donald Trump, obviously. And she talks about the use of the 1512 statute to compel people to testify. And she talks at great length about it being a foregone conclusion that, of course, people obstructed justice. And this is what warranted so much of the committee activity. Will she do an amended report if the Supreme Court says, hey, wait a minute, that statute shouldn't have been applied here, that it shouldn't have been applied to rioters? Liz does win the Dumb Blonde with a Powerful Daddy Award of the Week for this, the 49th week of 2024. Quick comment. Well, I guess not a quick comment. Hey, Alex, and Mike, to your point about a dam bursting and things changing, I think Alex Jones' reemergence on Twitter is a sentinel event. And I noticed you sent me a link yesterday that he's now going to have a daily Twitter feed. And you can find it at Real Alex Jones, and he promises 5 to 15 minutes per day of boiling down what he's otherwise put on the air. I view Twitter as a lifeline to populism. And I don't view populism as a threat to the American Republic. I don't view populism as a left-handed form of authoritarianism. I view authoritarianism as the emergence of a public health state and an elite that decides they know best what we should read, what we should think, how we should live, and what we should do. And Alex Jones and InfoWars are on the front line of that fight. So folks, take a look at Real Alex Jones on X. He promises potentially daily content on Twitter. He's calling it Alex Jones 2.0. And I gather it'll come in the evening after his show. So if you don't have time to watch InfoWars, take a look at that and ask and try him on for size. I think you'll find that he is far more than the stereotype. And on that stereotype, today is the 11th anniversary of the Sandy Hook shootings here in Connecticut. And, Justin sent me a note. It would be a good day to give a tribute to those folks. It would be a classy thing to do. I'm sorry to disappoint you, Justin. I'm simply tired of hearing about the Sandy Hook parents. It's been 11 years. Alex Jones has been demonized for his conduct with respect to those parents. It's a small part of what he says and does. The world moves on. And however tragic the loss of the children and dead loved ones were at Sandy Hook, the rest of us have gone on living the lives that we have. And we have to make value decisions and value choices about what to do with our world and how best to make it conform to our dreams. And I don't think we want to make profits and prophetesses out of those who suffered horrifying losses. An ancient maxim of the law is that no one can be a judge in their own case. And I don't think we want to make those who have lost catastrophically judges in the cases of others. So on this anniversary of Sandy Hook, I say it's been 11 years. Okay, let's move on. Every year, the event becomes smaller in the mind of the collective conscious of all living people, because we're about the business of living our lives, not reliving the traumas of others. But here's what I worry about with Alex and his newfound perch on X. It's going to increase his revenue stream. And that's going to make it was coming. Yeah. It's going to make it more. It's going to make it more impossible and more difficult to settle his bankruptcy.
Assuming that any of the advertisers come back. So here's your embedded defense. We just had all of the major corporations, Fortune 500 and otherwise, conspire to deprive X of any of their advertising revenue. So where is the revenue from that going to come from, other than just directly to Alex? Right, in terms of people visiting the site and stuff like that. So at least with respect to him being on X, I don't know that the mere existence on X is anything more than an opportunity for more eyeballs. But I also don't think, Norm, that he was really deprived of the same viewership that was on X just because he was.
That's true.
And so they will have a very difficult time if they have a judge that asks for any level of scrutiny or thoroughness in a legal theory or a damages theory. They'll have to at least show their work there. And not to say
they've never been required to show their work. That's been the point of the defaults. And Alex's appeal of the Sandy Hook judgments in both Connecticut and Texas, those appeals will be heard sometime in 2024. I know I'm handling the Connecticut appeal of the $1.5 billion verdict, and the issues are fully briefed, awaiting assignment to a panel. I believe the plaintiffs are due to file their brief in Texas soon, and we expect to argue those cases. Although, interestingly enough, while we're on the topic of lawfare, it's unclear, whether I'll be able to argue Alex's brief in 2024, because the Connecticut Appellate Court will hear the appeal of Judge Bellis's decision to suspend me on January 2nd at 2 o'clock. Now, those from afar may look at all these and say, wait a minute, the same judge who tried Alex's case, the same judge who entered a default against Alex, the same judge who made it almost impossible for Alex to utter a word in his own defense, that same judge is suspending Alex's lawyer when he's taking an appeal for her abusing her discretion? Is she trying to keep him quiet, trying to make sure that he doesn't, given his mastery of the record, give the appellate court an insightful analysis of what actually went on in that trial? I'm not that cynical, but some will say, watch out. And so we're apprehensive here, on pins and needles. That my law license was suspended abruptly because I shared with co-counsel in the case in Texas records that his office mistakenly gave to the plaintiff's lawyer in Texas. And when the judge read about this in the newspaper, she erected her own proceeding, a show cause proceeding. I appeared at the proceeding, and rather than answer questions, I pled my right to remain silent under the Fifth Amendment. She was so outraged, she yanked my law license for 6 months. When I asked her to stay it so I could get an appellate court to review it, she said no. So we went to the appellate court and got a stay there. That case will be argued January 2nd. I may have more time for law and legitimacy than you think next year, depending on how that decision goes.
Well, look, it's a catch-22, right? But we will, if that's indeed the case, Norm, we will make.
Oh, wait a minute. What is Justin Carter saying here?
CNN denied to Vivek that any informants were in the crowd on J6. He's asking us to discuss tomorrow. I think that we will, and I'm going to send you the video.
Lie. CNN. I actually have CNN.
Did you watch the video? Did you watch the video between?
No. I mean, okay. I don't watch CNN. I mean, I'm about as likely to watch CNN I am to drink cat urine in the morning for its nutritional value. Why would anybody watch CNN?
Well, Vivek went on a panel on CNN. He went to a town hall on CNN because that's who Vivek is at this point, right? He is going everywhere, and he is bringing his message everywhere, and he's challenging anyone to a debate, which is, again, a respectable quality in somebody of his intellectual caliber as well, that he will stand in the lion's den and he will fight. But Justin, you're right, and I watched the video. We won't spend too much time on it this morning. I'll only bookmark it for us tomorrow, Norm. I'll send you the video. I'll kind of present it without comment, and then you can tell me what you think. Yeah,
let's do that, because I've got a certain briefing book that was given to me by the Justice Department that a court ordered me not to disclose to the public, containing information about actual confidential human sources embedded in the Proud Boys in the weeks and months before January 6th. There was actually trial testimony, CNN, at the Proud Boys trial from a confidential human source who was reporting to the FBI as the breaches took place. CNN, don't let facts get in the way of your bullshit.
Well, we'll end with this. Not a ton here.
Oh, I wound up. There's nothing in my coffee, Justin. It's just reality. I love the smell of napalm in the morning.
Coffee. Governor Stitt signs anti-discrimination executive order, takes aim at DEI measures. This came through yesterday later in the day. I'll put the tweet up or the post up. I'm sorry, Elon. I really am. I mean to say post, and I respect what
I'll put the X on the spot, Elon. Oh, no, I don't want to put your son there. No, never mind. Who names their kid X anyhow, Elon? I mean, seriously, come back to us.
Governor Kevin Stitt of Oklahoma posted this yesterday. We'll celebrate our diversity without the DEI bureaucracy. My new executive order takes DEI politics out of higher ed and state agencies because Oklahomans deserve a merit-based system that ensures equal opportunities for everyone. So amen to that. Here's the oklahoma.gov website with the story. If anybody wants to go and read that, it is Executive Order 2023-31, implementing greater protections for Oklahomans and their tax dollars against diversity, equity, and inclusion. And just quickly, the order requires state agencies and institutes for higher education to initiate a review of DEI positions, departments, activities, procedures, and programs to eliminate and dismiss non-critical personnel. State agencies and institutions for higher ed shall not utilize state funds, property, or resources to 1. Grant or support diversity, equity, and inclusion positions, departments, activities, procedures, programs, etc., to the extent they grant preferential treatment based on one person's particular race, color, sex, ethnicity, or national origin. 2, mandate any person.
Wait a minute. What are we going to do about Kwanzaa?
Look, and look at in the 2, 3, 4, 5, and 6 are talking about mandating or coercing behavior based on any of this. Mandate any person to disclose their pronouns. Awesome. Mandate any applicant for employment provide a diversity, equity, or inclusion statement. Mandate any person to certify or declare agreement with, recognition of, or adherence to any particular political, philosophical, religious, or ideological viewpoint. Mandate any person swear, certify, or agree to any loyalty oath. So this is good. This is good. It's not great. It's good. It's right. The issue now is going to be the culture that already exists, right? That sort of artifice that exists in between what we label things. Because what we know of the modern political left from a cultural perspective is their intention and their willingness and their proven track record of commandeering language, twisting it, and then moving into a different vocabulary or lexicon to initiate the same shit that has not worked or has been deployed to a toxic effect in the past. So great that this is what we're doing, but it seems a little late. Culture is where this is going to change.
Prediction: there'll be a lawsuit challenging this in a court in Oklahoma by 5 p.m. today. Count on it.
Well, we'll see. We need to do a prediction show. When do we want to do that?
Well, so folks, we're talking about potentially taking the week off between Christmas and New Year's so that you guys can enjoy your holidays and not deal with the existential threat that comes of listening to Mike and I. I mean, there's only so much reality and truth that a person can take before their head explodes and said, wait, this isn't the best of all possible worlds? Holy cow. You mean Augustine might have been right about the fallen nature of man and there may be something to original sin? And when I look in the mirror, I say with Apostle Paul, all have sinned and fallen short of the glory of God. That which I would do, I don't. That's what I would not do, I do. You mean that might be real? We might take a week off. We're thinking about it. We'll announce that later. So let's next week do a show on predictions. All right.
I'm good with that. All right. We'll do 5. Maybe. No, what do we want to do? Well, hold on. We'll do a show where we assess the outcome of the predictions that we made at the beginning of this year. So we'll remind everybody where we were. And then we will maybe as 2 separate shows.
Yeah.
Maybe we analyze that. And then we'll do 5 more. So what do you say?
Maybe we'll do a show where we just say, OpenAI, tell us what we'd say if we wanted to talk about X, Y, or Z, and we'll just see how right it is. You know,
we can do OpenAI versus Grok, right?
That works. Hey, folks, thanks for tuning in today. We had a good time. I hope you did, and the coffee was good this morning, Jason. Thank you. Where do folks find us, Mike?
They can find us here on X at LawPod Daily. I really want to hawk that, but I know that also we have the greater weight of our participation every morning is over on Rumble. So I want to specifically acknowledge everybody over there. Thank you for showing up and participating in the chat. You know, it's always great for me to look over and be able to see the comments going back and forth with so many of you. So we're over on Rumble as well as on YouTube. We're live there, all 3 of those places every morning, 8 a.m. Eastern time, Monday through Friday. So please, if you're not already subscribed, hit the subscribe button. If you haven't liked the video that you're currently watching, please do that. And if you're feeling inclined, please enable notifications so that you know when we go live on each of those respective platforms. We're also on Apple Podcasts, Spotify, Google Play, Overcast, Audible, wherever you find premium podcasts. The audio-only versions are uploaded every single day directly after the show. The only delay is however long it takes for me to download the audio file from StreamYard. So you can find us there. You can also find us on Locals. I think it's been a little while since I ran the banner down below. For those of you that like to be, made aware if we're not going to be streaming on a particular day, I've said this in the past, Norm, but worth noting again, we post to Locals, we post to X, but we post to Locals, and what we do is we actually make it such that notification will go to your email. So if you want advance notice of any changes in the schedule, if we're going to be streaming on a different day or whatever, Locals is sort of your home base, right? So put your email in. Make sure that you enable notifications there, and any changes to the schedule, you will be made aware at least an hour in advance, so you're not waiting around till 8 a.m. and then something doesn't happen, or you're waiting for the algorithm to give you the information that we put out on X or otherwise. So that's where you find us. And again, you can always just Google Norm Pattis and you'll find him, right, in the New York Times or somewhere else.
And Mike, stick around for a few minutes after we log off. I need some information. Like, what is Locals?
It's the red button at the bottom of the YouTube video, everybody. Anyway, Norm, we will talk Hey, Rose.
Oh, there it is, Rose, baby. Gnaws your ear off. Rose, good girl. Rose. Oh, she's looking. Hi, my name's Joe Biden. I gotta pee. Hunter.
All right. See you guys tomorrow. See you, North.
Bye.